Part 5. Inherent powers of courts. Every court is constituted for the purpose of administering justice between the parties and therefore must be deemed to possess as a necessary corollary all such powers as may be necessary to do the right and to undo the wrong in the course of administration of justice. As stated above, Code of Civil Procedure is a procedural or adjective law and the provisions thereof must be liberally construed to advance the cause of justice and further its ends. The inherent powers of the court are in addition to the powers specifically conferred on the court by the court. They are complementary to those powers and the court is free to exercise them for the ends of justice or to prevent the abuse of process of the court. The reason is obvious. The provisions of the code are not exhaustive for the simple reason that the legislature is incapable of contemplating all the possible circumstances which may arise in future litigation. Inherent powers come to the rescue in such unforeseen circumstances. They can be exercised ex debito justitiae in absence of express provisions in the code. As Justice Raghuveer Dayal rightly states, the inherent power has not been conferred upon the court. It is a power inherent in the court by virtue of its duty to do justice between the parties before it. Thus, this power is necessary in the interest of justice. The inherent power has its roots in necessity and its breadth is coextensive with necessity. Sections 148 to 153A of the Code enact the law relating to inherent powers of the court in different circumstances. Inherent power meaning. According to dictionary meaning, inherent means natural, existing and inseparable from something, a permanent attribute or a quality, an essential element, something intrinsic, essential, vested, and attached to a person or office as a right of privilege. Inherent powers are thus powers which may be exercised by a court to do full and complete justice between the parties before it. Inherent powers scheme. Sections 148 to 153b of the Code deal with the inherent powers of courts. The scheme, however, is not based on intelligible pattern. Section 148 and 149 provide for grant and enlargement of time, while 151 preserves the inherent powers of courts. 152, 153, 153a deal with amendment in judgments, decrees, and orders, and in other proceedings. Section 153b declares a place of trial to be an open court. Section 150, however, provides for transfer of business. This section could have been placed along with Section 22 and 25, dealing with transfer of cases. Likewise, Section 148a, lodging of caveat, could have been taken either with Section 26 to 32, dealing with institution of sorts, or before 148 or after Section 153b. Enlargement of time. Section 148. Section 148 provides that where any period is fixed or granted by the court for doing of any act, the court has the power to enlarge the said period even if the original period fixed has expired. Where a court in the exercise of its jurisdiction can grant time to do a thing in the absence of specific provision in the contrary, curtailing, denying, or withholding such jurisdiction, the jurisdiction to grant time would include in its ambit the jurisdiction to extend the time initially fixed by it. The use of the word may indicates that the power is discretionary and the court is therefore entitled to take into account the conduct of the party praying for such extension. The principle of equity is that when some circumstances are to be taken into account for fixing a length of time within which a certain action is to be taken, the court retains to itself the jurisdiction to re-examine the alteration or modification of circumstances which may necessitate extension of time. If the court, by its own act, denies itself the jurisdiction to do so, it would be denying to itself the jurisdiction which, in the absence of a negative provision, it undoubtedly enjoys. In the words of Hidayatullah, conditional orders are not like the law of Medes and Persians. Justice Desai states that the danger inherent in passing conditional orders becomes self-evident because that by itself may result in taking away jurisdiction conferred on the court for just a decision of the case. The true purport of conditional orders is that such orders merely create something like a guarantee or a sanction for obedience of the court's order, but would not take away the court's jurisdiction to act according to the mandate of the statute or on relevant equitable considerations, if the statute does not deny such considerations. Before extension of time is granted by a court, two conditions must be fulfilled. A period must have been fixed or granted by the court, and such period must be for doing an act prescribed or allowed by the court. The section has no application when the time has not been fixed or granted by the court or a particular act has not been prescribed or allowed by the court. The power conferred by the court on the court is discretionary. The court may use it for securing ends of justice. It cannot be claimed by the party as of right. Before exercising the power, therefore, the court may take into account all the facts and circumstances, including the conduct of the applicant. Payment of court fees. Section 149. Section 149 empowers the court to allow a party to make up the deficiency of the court fees payable under plaint memorandum of appeal even after expiry of the period of limitation prescribed for filing such suit appeal. Section 4 of the Court Fee Act provides that no document chargeable with court fee under Act shall be filed or recorded in any court of justice unless the requisite court fee is paid. Section 149 of the CPC is a sort of proviso to that rule by allowing the deficiency to be made good within a period fixed by it. If the proper court fee is not paid at the time of filing of memorandum of appeal, but the deficit court fee is paid within the time fixed by the court, it cannot be treated as time barred. Thus, the defective document is retrospectively validated for the purpose of limitation as well as court fees. Power, however, is discretionary and should be exercised judicially and in the interest of justice. Transfer of business, Section 150. Section 150 of the Code declares that where the business of any court is transferred to any other court, the transferee court will exercise same powers and discharge same duties conferred or imposed by the court upon the transfer court. Ends of justice, Section 151. Inherent powers saved by Section 151 can be used to secure the ends of justice. Thus, court can recall its own orders and correct mistakes. It can set aside an ex parte order passed by against the party. It can issue temporary injunction in cases not covered by the provisions of Order 3922, can add, delete or transpose any party to the suit, can set aside illegal orders or orders passed without jurisdiction, can revive execution applications, can take notice of subsequent events, can hold trial in camera or prohibit excessive publication of its proceedings, can allow amendments of pleadings, can correct errors and mistakes, can expunge remarks made against a judge, can extend the time for payment of court fees, and can extend time to pay arrears. Arrears of rent. Can restore the suit and rehear it on merits, can review its orders. What would meet the ends of justice would always depend upon the facts and circumstances of each case and requirement of justice. Abuse of process of court, Section 151. Inherent powers under Section 151 can also be exercised to prevent the abuse of process of court. Such abuse may be committed by a court or by a party, where a court employs a procedure in doing something which it never intended to do, and this is miscarriage of justice. There is an abuse of process by the court itself. The injustice so done to the party must be remedied on the basis of the doctrine actus curiae neminem gravabit. An act of the court shall prejudice no one. Similarly, a party to a litigation may also be guilty of an abuse of the process of the court by obtaining benefits by practicing fraud on the court, or upon a party to the proceeding, or by circumventing the statutory provisions, or by resorting to or encouraging multiplicity of proceedings, or by instituting vexatious, obstructive, or dilatory tactics, or by introducing scandalous or objectionable matter in proceedings, or by trying to secure an undue advantage over the opposite party. Amendment of judgments, decrees, orders and other records, Section 152, 153, 153A. Section 152 enacts that clerical or arithmetical mistakes in judgment, decrees or orders arising from any accidental slip or omission may at any time be corrected by the court either of its own, suo motu, or on application of any parties. Section is based on two important principles. 1. An act of the court should not prejudice any party. 2. It is the duty of the court to see that their records are true and they represent the correct state of affairs. In the words of Bowen, every court has an inherent power over its own records so long as those records are within its power and that it can set right any mistake in them. An order, even when passed and entered, may be amended by the court so as to carry out its intention and express the meaning of the court when the order was made. It can be done at any time. Illustration: A files a suit against B for 10,000 rupees in court X. The court passes a decree for 1,000 as prayed. The decree can then be amended to 10,000 under this section. A files a suit against B for 10,000 and interest in court X. The court passes a decree for 5,000 only and nothing more. A applies to amend the decree by adding a prayer for payment of interest. The decree cannot be amended under this section. If aggrieved by the decree, A may file an appeal and application for review. Section 153A, as inserted in Amendment Act of 1976, provides for where the applicant court dismisses an appeal summarily. Under Order 41, Rule 11, the power of amendment under Rule 70, Sections 152 can be exercised by the court of first instance. Section 152 is confined to amendments of judgments, orders or decrees. Order 6, Rule 17 deals with amendment of pleadings. Section 53, however, confers a general power on the court to amend defects or errors in any proceeding in a court and make all necessary amendments for the purpose of determining the real question at issue between the parties to the suit or other proceedings. Limitation. It is true that inherent powers of the court are very wide and residuary in nature, and they are in addition to the powers specifically conferred in the court by the code. It is, however, equally true that these inherent powers can be exercised ex debito justitiae only in the absence of express provisions in the code. They cannot be exercised in conflict with what had been expressly provided for in the code or against the intention of the legislature. If there are express provisions exhaustively covering a particular topic, they give rise to necessary implication that no power shall be exercised in respect of said topic otherwise than in the manner prescribed by the said provisions. Again, the inherent powers are to be exercised by the court in a very exceptional circumstance. The restrictions on the inherent powers are not because they are controlled by the provisions of the court, but because it should be presumed that the procedure provided by the legislature is dictated by interest of justice. Thus, in the exercise of inherent powers, a court cannot invest itself with jurisdiction not vested in it by law, or grant an order of stay circumventing the provision of section 10 of the code, or allow set off in execution proceedings in the instance of an auction purchaser, ignoring the provisions of Order 21, Rule 84, or a remand a case ignoring the provisions of Order 41, Rule 23, and reopen the questions which had already been heard and finally decided by it and which are consequentially barred by the general principles of res judicata, or appoint a commissioner keeping aside the provisions of section 75, or review its orders or judgments in the absence of statutory provisions, or direct an arbitrator to make a fresh award, or set aside an ex parte decree ignoring the provisions of the Order 9, Rule 9, or override substantive rights of any party, or restrain any party from taking proceedings in a court of law, or implead a legal representative on record after the suit is abated, or make an order restraining execution of the decree against the surety, or set aside an order which was right when it was made. Concluding remarks. Section 148 to 153b of the Code invest courts with a very wide and extensive power to minimize litigation, avoid multiplicity of proceedings, and to render full and complete justice between the parties between them. Section 151 of the Code is a salutary provision of the safe inherent powers of the court, which are to be exercised ex debito justitiae in the interest of justice. They have not been conferred upon the court. They are inherent in every court by virtue of its duty to do justice in the cause. It is submitted the following observations to borrow. Lay down the correct principle regarding the ambit and scope of inherent powers of a court under section 151 of the Code, wherein His Lordship, after considering all leading cases on the subject, pronounced the inherent power of a court is in addition to and complementary to the powers expressly conferred under the Code, but that power will not be exercised if its exercise is inconsistent with or comes into conflict with any of the powers expressly or by necessary implication conferred by the other provisions of the Code. If there are express provisions exhaustively covering a particular topic, they give rise to a necessary implication that no power shall be exercised in respect of the said topic otherwise than in the manner prescribed by the said provisions. Whatever limitations are imposed by the construction on the provisions of section 151 of the Code, they do not control the undoubted power of the court conferred under 151 of the Code to make a suitable order to prevent abuse of the process of the court.